Well, welcome everyone. Thank you for joining us today for the first in our webinar series on patient data licensing. My name is Kirsten Loita, and I'm a partner at Osage University Partners, leading our university relations efforts. I'll be in the background for most of today as we have a terrific panel joining us for this first in our webinar series, What is the Data? Including our guest moderator today. So I won't be moderating. Drew has kindly agreed to moderate for us. And I'm going to have, let's go to the next slide. I'll have each of the people joining us introduce themselves, and I'll do a bit of housekeeping before we pass the baton to Drew to do the moderation today. Drew, could you introduce yourself?
Hi, I'm Drew Bennett. I'm with the University of Michigan licensing team. And as Kirsten mentioned, happy to be facilitating today.
Terrific. Nick.
Hi, I'm Nick Rosowskis. I'm the Technical Director of the Human Imaging Research Office at the University of Chicago, among other things.
Great. David?
I'm David Peliquin. I'm a partner at the law firm of Ropes&Gray in Boston, and I advise academic medical centers, life sciences companies, and universities on issues in research and development. We spend a lot of time talking about reuse and secondary uses of data.
Terrific. As you can see, we have a terrific panel handling this subject today. We'll go to the next slide. This webinar is in the first of a series of webinars that we are producing that cover what is the data, that's today. Then what can we do with the data? That's on March 21st of 2023 with panelists John Plummer of Vanderbilt Medical Center and Gavin Foltz of Duke University. For that webinar, we'll be sending out the registration materials in a few weeks. And then the third webinar will be how are academic institutions licensing patient data? That'll be on May 15th of 2023 with panelists Stephen Gardner of Quarles&Brady and Angela Kujak of the Broad Institute. We actually are already considering a couple of additional webinars based on some feedback we've already received that conclude case studies and further questions that have come up as we've explored this series of webinars. So we'll go to the next slide. We did want to mention that Ropes&Gray is helping us out by offering CLE credits for today's and the future webinars, and they're able to provide one California General Credit, one Illinois General Credit, and one New York Transitional Professional Practice Credit, as well as matching reciprocal credit in New Jersey and Connecticut for this program. We sent the attorney affirmation form prior to this webinar to all registrants. If you didn't get this, let us know. We can send it out again. Attendees will only receive CLE credit if they submit an affirmation form. We also sent an evaluation form that can be returned to the CLE team at Ropes&Gray as well. We will tell you this code for the CLE credit about midway through this webinar. So we can go to the next slide now. The slides and recording of this webinar will be available on OUP's partner portal, and a recording will also be available on our YouTube channel. The partner portal is an online portal for the tech transfer officers and researchers at our partner institution. It's full of relevant tech transfer and startup content. So once you're in the portal, for which you'll need to register if you have not already, you'll find a downloadable presentation deck and video link for this webinar on the webinars page, which is under the startup resources section. As I mentioned, we will also have this available on our YouTube page, and everyone who is registered for this webinar will receive a copy of the decks, as well as a link to the recordings themselves after the webinar. We are going to encourage questions throughout this webinar. Please use the Q&A tool in the Zoom to submit your questions instead of the chat. Please don't use the chat function. It's easier for us to track the questions in the Q&A tool. We did receive a bunch of questions ahead of time, and Drew will ask those of our panelists as we go through the webinar. Some of the submitted questions are more appropriate for future webinars that we're holding, so we're going to hold off on those until those future webinars. We'll go to the next slide. So a short intro on OUP for those of you who don't know us. We are a venture fund that partners with academic institutions to invest in their startups, typically by exercising participation rights available through their licenses. As part of this partnership, the institutions share in our profits and receive programmatic support on tech transfer and academic startups, such as this particular program. We're now on our fourth fund. I've made over 130 investments in all of our areas. We can go to the next slide just to show people the types of areas that we invest in. We invest in the deep sciences where our universities partners are creating wonderful technologies. If you have any more questions on this, please do let us know. But that's not the focus of this webinar. We'll go to the next slide. The focus of our webinar obviously is on data licensing. What is the data? And I'm going to pass this now to Drew to run through the origins behind this webinar series, as well as the agenda for today. Drew?
You bet. Thanks, Kirsten. Really excited to facilitate today's session, and it would be remiss of me not to mention kind of the backdrop here. Last year, Osage was good enough to get a number of different folks together to say, hey, should we have this series? If we did have it, what would that content be? And I was very fortunate to work with people from Vanderbilt, Duke, UCLA, UChicago, Stanford, Florida, and a variety of other folks, including some of the experts we're going to have on the series to get this content out to folks. Super enthusiastic about that. The interest is very, very high. Today is really the foundational piece. For some folks, this might be kind of reviewing some things. For other folks, it's going to be foundational types of things, but the series is built one upon the next. And the intention here is to basically lay the landscape out, the foundations of really what we're talking about in terms of data. And as the agenda says, kind of where does this data come from, the different types that are out there, where are the sources? And then David's certainly going to help us with the legal considerations and oversight, because you can't really talk about this topic without having the legal aspect of it come close behind it. So again, thrilled to be facilitating this. Please ask your questions. We're going to take appropriate pauses throughout to try and get those questions answered in context and really get them to you at that time so that they make the most logical sense. So please make sure you do that. And again, the slides and the video are going to be available at the conclusion. That's always a favorite question for people to ask in the chat, but they are absolutely going to be available. So that's great. Don't feel like you have to take furious notes in order to keep up with things. So with that said, I'm going to turn this over to Nick and let him get us started, and enjoy today's presentations.
Thanks, Drew. So I thought we would start out today just by briefly discussing the type of data that we're actually talking about. So in my capacity at the University of Chicago, I will often be part of the team that requests data or reviews data requests from outside entities and determines whether or not we actually want to share that data or license it for whatever the use case might be. And then depending on the type of data, my team might actually be the one that actually pulls the data and does whatever needs to be done to process it to deliver it to the requester. So we want to talk a little bit about both the types of data and where they come from. Next slide, please. When we're talking about the types of data that we're dealing with here, it's good to know where the data itself likely comes from, like how it originated. And so very broadly speaking, we have sort of three basic groups of data that we'll probably be talking about here. So the first and probably the largest amount or largest category of data is data that would have been generated as part of routine clinical care. So this is any type of clinical data that is derived from a patient who seeks care within the providing institution. If you go see your doctor and they, record vital signs, they prescribe medication, you get some tests done, that would be data generated under the guise of routine clinical care. The next broad category we have is data generated as a result of what we would say is a research intervention. So broadly, this could be data that has been generated as a result of the patient's participation in a clinical trial. And so when we talk about clinical trials, this would typically be like a prospective, therapeutic, industry-funded trial. Most typical example of this might be a trial that's being run by a pharma company to determine if their new drug works. And so participants in that trial may undergo additional tests that may not normally have been ordered as part of their routine care, but are being ordered in order to help evaluate the therapeutic agent under investigation in the trial. And so that data will typically reside alongside a lot of the data that's generated for routine clinical care. But it may sometimes be indistinguishable, but there could be caveats attached to data that's been generated in that way. And then also sort of more broadly speaking, we may have data that's been generated as part of just a research study. And so a clinical trial is sort of like a specific type of research study, but more broadly, we may have research studies that have been initiated by investigators at the institution. This could be as simple as having participants fill out questionnaires regarding, their healthcare or their perceptions of the care that they're receiving. And it can get even to more complicated things, which is more my line of work, where you might have an investigator at the institution who is looking into new different ways of performing certain types of medical imaging scans, for example. And so again, that type of data has only been generated as a result of the research study, but it may or may not be stored with the rest of the patient's records and may or may not be of utility to someone who's looking to obtain this type of data. And then finally, we have types of data that have been generated by investigators purely for research purposes. So that could be data generated in a research lab at the institution utilizing the other types of data above. Probably less likely to talk about that type of data today, but certainly still a type of data that may be available as well, depending on the type of project that you're working on. So next slide. So now that we know the types of, or where the data is coming from, what are we talking about very broadly? So when we are looking at requests for different types of clinical data, we've got, again, a handful of broad categories, and I'll go really fast if you've got any questions on what some of these might be and maybe what their utility is. Happy to take questions on them. We'll have data that's found, what we would call like narrative data, or just like giant globs of text. And this includes things like physician notes, surgical notes, history, H&P notes, history and physical notes, radiology reports, pathology reports, essentially anything that's almost written like a story in describing the encounter that the patient had with the provider or the institution in general. So these will usually be written up as prose text. It's some of the more complicated types of things to extract it and get useful information from, but it is also very rich and useful. And so lots of data requests will typically encompass these types of information. And this is the way that they're typically formatted, usually just written up by the physician or the provider. We also have what we broadly refer to as like alphanumeric values or enumerated data. And so this is sort of a more nitty-gritty types of information you might be thinking of, and certainly your database administrators, if you're in a research lab, would love to get. So this is demographic information about the patients in the cohort that you are looking to obtain, names, dates of birth, ethnicity, that type of thing. Lab results, if patients have had, cholesterol tests or blood work done, and those tests results in numeric values. Cholesterol is 48 and it has a unit associated with it, things like that. Results of procedures like pulmonary function tests, things that may have like true or false associated with them, or generate other types of numeric data. Importantly, things like ICD and CPT codes. These are diagnostic and billing codes that help you group patients together, like why were certain procedures ordered, what specific type of procedure was it, what ailments does the patient have, what's their history, that type of thing. ADT data, which is admit, discharge, transfer data, like when was the patient admitted to the hospital, what unit were they admitted into, when were they discharged. Medication data, just what it sounds like. Flow sheet data, which is any vital signs that might have been collected while a patient is, an inpatient or has been or seeing their physician. Basically, any kind of quantitative data or data that falls within a range and has specific units that's been appropriately discretized. You'll find this type of data is plentiful as well, and is usually stored in a variety of different systems. And this is the type of stuff that at least has some kind of curation associated with it. So it's usually easier to deal with, for example, than narrative text, but not that you can't deal with both. Next slide.
So Nick,
Yeah.
already kind of question coming. It's I think it's a good one relative to like, who are the type of people you might be talking about trying to get an understanding of this data? Is it technicians, IT people, physicians, therapists? What type of folks would you end up talking to in that regard?
In order to like obtain the data, for example?
I think that's the context, yeah. Or
Sure.
good understanding of what I guess the
Of
asset.
what you might actually need and where it would come from, right? I think in my next slide, which I'll get to in a little bit, I'll talk about that a little more specifically. So I'll keep that in mind. But it can depend, for example, on how sophisticated the institution is that you're hoping to gather the data from. Like at University of Chicago, we have consultants whom you can bring your project to, and they can help determine, based on what it is you're trying to do, what types of data might be available and what might be most useful. If you're dealing with an institution that doesn't have that, and you don't have someone that you can go to for clinical expertise or medical expertise, then yeah, it's difficult to say. This is probably where sort of consultants would come in. So folks who, like physicians or other types of research folks who have dealt with this data, more in their daily life and could tell you like what's useful and what's not. If the institution has machine learning folks or consultants within their group that can help out, then certainly you can usually engage them. But yeah, it's difficult to if you don't already know. It's one of those things where, I mean, there's totally a wealth of information, and it can be difficult sometimes to figure that out. So you'd probably have to seek out someone who has some experience in it if it's not already available. Hopefully that answers the question, but I'll talk a little bit. I have at least one bullet point coming up that maybe will help clue some people in. So just to finish up here. So additional types of data includes images, which is the team that I lead is primarily involved in. So we were talking about medical imaging that you may be familiar with if you've ever gone to a doctor and they've said that you need to get a CT scan or an MRI or an X-ray, all those types of things. So those images are available at all these institutions more often than not now, and can absolutely be used in research, and often are. This can also include things like ECG or EMG or EEG tracings. Those are usually produce images of some type. Also just the types of images you might be familiar with, photographic images and videos from endoscopy, bronchoscopy, skin photography, that type of stuff. Eye imaging from eye clinics. There's a number of different types of imaging that can be done of the eye, and all sorts of other images that might be acquired in non-standard or proprietary formats. All of this stuff usually stored in databases somewhere and is available. We see lots of requests for these types of things for machine learning projects all day long. And then finally, just very generically, other types of documents like PDFs that might be generated by other types of clinical equipment or pieces of paper that get scanned in. A lot of times those just get attached to patient medical records as well. So another type of data that may contain information that might be of use, again, depending on what your project is. Next slide. Okay, so what are the sources of these data? Where can you find these types of things? This gets a little bit to the question that Drew posed. So most of the information that we talked about is likely to be found in the electronic medical record system of the institution or the provider that is storing the information. Electronic medical record systems have only gotten more big and complicated. They tend to be very broad systems that include a number of components, and each of those components might store different types of data, but that would be the folks at the institution who could help you figure out where you might need the particular information you're looking for. Billing systems also contain a wealth of information. Frankly, a lot of electronic medical record systems are driven by the billing system in the back end. And so that's where things like diagnosis codes and procedure codes and all of these other types of things are often found. Of course, every department within a hospital or institution likely has its own information system that contains even more detail about the specific workflow and operations of just that department. The most common examples of those are radiology and laboratory information systems. The radiology department is going to have something that drives its workflow and stores very specific information about radiology. Laboratory is similar, pathology is similar. A lot of that information will wind up in the medical record system, but not all of it. Departments will also often have image archives if they generate images. Again, radiology image archives are the biggest ones. They're called PACSs. That's where most imaging gets stored, but usually not all of it. At UChicago, cardiology has their own image archive. OBGYN has their own image archive. So again, depending on what you are hoping to accomplish, you may need to be looping in all those other teams as well. And then to Drew's point, clinical research data warehouses, or sometimes called electronic data warehouses, are becoming increasingly common, particularly at large academic medical centers and other research institutions. And these groups will usually maintain copies of a lot of the types of data sources that we see here, specifically for the purposes of conducting research and for extracting research data. So these teams can often have experts or consultants on them who will be able to help you with, for example, I have a project I'm hoping to determine, I need to do some machine learning, or I'm hoping to determine if the following things are true given certain conditions, and what types of information is being recorded already that I might be able to utilize, it would be the folks within the clinical research data warehouse or electronic data warehouse at the institution who are most likely able to help you out with that directly. And then because they also are the sort of the gatekeepers of their warehouse that has the data in it, they will most likely be the ones to facilitate actually getting you the data. So if you've got an institution that has that, those are your guys.
Yeah, Nick, do you have any ideas? There's a question relative to if you have consultants, any experience with respect to that, who they might report through, or kind of how that structurally works?
Yeah, so it's the caveat is it's almost certain to be specific to the institution, for example, right? So at University of Chicago, our clinical research data warehouse, for example, is its own team within our biological sciences division. They report up through basically our dean's office. Importantly, I think I saw a question go by was, are they part of the tech transfer office? And no, they're not. I would suspect that in most cases they probably aren't, because one of the reason why a lot of these warehouses are initially formed is actually to support the research of like faculty and laboratories within the institution itself. So if I'm doing a research project at U Chicago and I need to get a bunch of patient information for my research project, I go to our clinical research data warehouse, as are, you know, other physicians or researchers. That's ideally where they would go to get the data. It just turns out that they would also be uniquely suited and usually will also review requests for data coming from third parties, outside parties, and so forth. Yeah, so it depends. I mean, I think sometimes maybe they'll be associated with their IRB. Certainly the IRB at the institution will be aware of their clinical data warehouse if they have one, so you can always check with them as well. And then finally, and it's slightly beyond the scope, but increasingly we're starting to see what are called electronic health record exchange networks, which are essentially, because it's becoming, there's a lot more technology available now to allow different institutions to share data with one another, especially electronically. We're starting to see a lot more technology that allows medical records to be shared between institutions that are otherwise unaffiliated, image data to be shared between institutions that are otherwise unaffiliated. If you've ever been to a doctor and their medical record system is Epic, which in the United States and particularly the Midwest is very popular. Epic has a feature called Care Everywhere, where any other hospital that uses Epic that you've been to can technically share their records with the Epic that's being used at the facility that you're at. I think there's going to be some interesting implications about, since I have access to Epic and my Epic has access to other institutions, what does that mean in terms of who gets to get what types of data? I feel like there will probably be questions about that in the very near term. But that is another avenue of data sources that are out there as well. And so I know I talked fast and that was a lot, but that's all I have. So I will happily turn it over to David at this point, unless there's other questions.
No, there aren't, but David, I'm going to load you up with a couple before you get started so you can weave it into the context of your presentation. But this is certainly a great question, and it's one that comes up a lot, which is just basically who owns the data collected under any of these circumstances. The question was about a clinical trial, but it's really the discussion about the sponsor or the institution. And then another question really about does copyright cover this data from a legal standpoint as a potential question there. So I'll let you answer those as you roll through, but something to think about. And folks, please feel free to keep sending the questions in. This is the ambition of the presentation.
And I think we'll get to the question on clinical trial ownership as we go through the presentation today. But before I forget, because I know for many attorneys on the line, this is going to be the most important part of the presentation for you. I have to say that for attorneys participating via teleconference, please note the following number on your affirmation form to earn the appropriate number of CLE credits. And that number is 8180. Again, the number for CLE credit is 8180. So I'm going to talk a little bit today about some of the legal considerations that come up in instances in which an academic medical center or a university that holds health data wants to share those data with an academic partner for research or with an industry partner for research purposes. Some of the concepts covered today, especially on HIPAA, may be a refresher for many of you, and they're fairly basic, but I still get a lot of questions about them almost every day in different incarnations. So I think it's good to level set and start with some of the basics here. So if we go to our next slide, I'm going to walk through a few different things. I think, Nick has already laid the ground for us, talking about how there's a lot of different data sharing initiatives that take place, different types of data that are held at academic medical centers and universities that folks would like to share for different research purposes. And there's different parties and structures, different approaches that we see taken. If we go to the next slide, the legal framework that we're going to talk about today is because we're talking about health data and the principal law governing the privacy and the use and disclosure of health data in the United States is HIPAA. We are going to focus on that a bit. I'm going to then talk a little bit about the common rule, the federal regulations on human subjects research, and that'll talk a little bit about how the IRB gets involved in these issues, and Nick had alluded to that earlier. And then, of course, we're in a federalist system in the United States where we have state law in addition to federal law. So we'll talk a little about the state law considerations that come into play, especially in sensitive information areas like genetic data, biometric data. And then we're going to talk a little bit about the provenance of the data. I'll call it, what is the source? And this goes back to Nick's presentation on, is it from clinical care? Is it from clinical research? And we can address the question about ownership of data from clinical trials, I think, head on there. And then we'll talk a little bit about other considerations in this space. So if we go to our next slide, so I think many of you are familiar with HIPAA, but it's important to take HIPAA into account when talking about sharing of patient data. And remember that HIPAA applies to the use and disclosure of protected health information, PHI. And what is PHI? It's information that's created by or received by a covered entity. And so in order for HIPAA to be relevant, we need a covered entity in the mix or a business associate acting as a vendor of the covered entity. Remember that covered entities are healthcare providers, health plans, and healthcare clearinghouses. And so you may have arrangements, let's say there's an independent research institute you're working with, or a clinical lab that does no traditional healthcare billing transactions. Those entities may not be covered entities. The information they generate may not be PHI. But usually in this space, we're talking about data that's originating with a hospital or other healthcare provider, or sometimes a health plan like a Blue Cross Blue Shield or Aetna. And those data would be covered by HIPAA as long as they relate to the health of an individual or the payment for the health care of the individual, and they identify the individual, or there's a reasonable belief that the information could be used to identify the individual. And PHI can be in electronic form, oral form, or written form. And so we're going to talk a lot today about that identifying the individual piece, because that's often key when we're thinking about the extent to which HIPAA governs these data licensing transactions, or is relevant for those transactions, I should say. If we go to our next slide, what we'll see is that HIPAA generally states that the use or disclosure of PHI for purposes other than treatment, payment, or healthcare operations requires the authorization of the patient or the research subject. And treatment, payment, and healthcare operations don't include research activities. They include maybe some analytics, business management activities, but not actually research. Research is defined separately in HIPAA. And so an authorization, a patient authorization, has to contain the description of the purpose for the requested use or disclosure. And the authorization can permit future research uses and disclosures if the language of the authorization adequately describes the future use, such that it's reasonable for the subject to expect that his or her PHI will be used in the future for a research study. And now often in an interventional clinical trial, the patient is signing an informed consent to participate in the study. So you can give me this investigational drug, here are the risks and benefits, but they're also simultaneously usually signing a HIPAA authorization for the use or disclosure of their PHI. So those are two separate permissions: consent to be in the trial, that's governed by the FDA regulations or the common rule, and then authorization for use and disclosure of PHI, which is governed by HIPAA. And so it's important, if we're in an interventional trial scenario and the authorization is being drafted and there's future research that we're thinking about, to consider whether that future research should be described in the authorization form. If we go to our next slide, there are alternatives, of course, to obtaining a HIPAA authorization, because there may be instances in which we're using data that was generated in standard of care or data that was generated in the past, or we need to look at the larger medical record. It may not be practicable to obtain a HIPAA authorization. And so alternatives can include de-identifying data such that there's no PHI, disclosing what's called a limited data set, which I'll talk about in a moment, which is often used in this space, Or if we're talking about a future research activity, it's possible in some instances to go to the IRB, the Institutional Review Board, or the Privacy Board overseeing the research to obtain what's called a waiver of HIPAA authorization. And I can say a little bit more about that in a bit. If we go to our next slide, PHI, of course, and I think many people are familiar with this, but it's important to be specific sometimes. PHI can be de-identified under two methods. One is the safe harbor method, which I'll talk about, and the other is the expert determination method. And if the covered entity, let's say a hospital or a health plan, doesn't have sufficient resources in-house to perform the de-identification activity, it's possible to engage a business associate to de-identify PHI on behalf of the covered entity. And that's because de-identification is considered a healthcare operation under HIPAA. And that's important to know because remember I said that covered entities can use or disclose PHI for their own healthcare operations. And so the covered entity can always choose to de-identify PHI on its own. That's part of its inherent healthcare operation function, or engage a business associate to de-identify PHI on its behalf. If we go to our next slide, now de-identification under the safe harbor method requires removal of 18 identifiers that relate to the individual or their relatives, employers, or household members. And the covered entity, even after you shed these 18 identifiers, and I have a slide that shows them on the next slide, the covered entities, that is the health system or the health plan that's de-identifying the data, can't have actual knowledge that the information that remains could be used either alone or in combination with other information to identify an individual who is a subject of the information. What that means is if you know that the recipient of the data is going to be able to re-identify it, even if you've taken off these 18 identifiers, it's not considered de-identified information under HIPAA. If we go to our next slide, this is a list of the 18 HIPAA identifiers. And the identifiers that tend to surprise people, I would say, are the dates. So all elements of dates except for year. And so that's not just date of birth. That also includes things like treatment date, admission date, transfer date, and also geographic subdivision smaller than a state that relate to the individual. And so let's say an individual zip code would have to be removed. So this is quite a strict standard of de-identification. One thing that is not on this slide is the name of the treating physician or the name of the health system at which an individual is treated. And that often is quite valuable information depending on what type of activity is being done. And so some of that information can remain here. And the other thing I point people to is this discussion of the last identifier, the any other unique identifying number, characteristic, or code. And so if there's a unique number that links to the patient that's not listed here, that will often have to be removed as well. If we go to our next slide, I do note that when we talk about any other unique characteristic or code, there's an exception in the safe harbor method that says there's ways to assign unique codes to patient data as long as it's not derived from any element of PHI. So it's not like a derivative of somebody's date of birth or their medical record number. And if it's only used for re-identification purposes, you may be able to code those data, but you'll have to look at that on a very fact-specific basis. And I've had a lot of discussions with clients and opposing counsel representing counterparties about the extent to which that exception that allows coding of data can be used. So it's important to look at that with your legal counsel under the specific facts. There's also a second method of de-identification called the expert determination method, which is increasingly used for data licensing transactions because it can allow for some more flexibility with respect to the types of identifiers that remain in a data set. So under the expert determination method, instead of shedding 18 identifiers, which is kind of a blunt tool used in safe harbor, an expert who uses generally accepted statistical and scientific principles and methods renders the information not individually identifiable using those techniques, and they render an opinion that the risk is very small that the information could be used either alone or in combination with other reasonably available information to re-identify the subject of that data. And they document that in an opinion, an expert opinion is often called. And this often, the expert will be able to get comfortable with the retention of certain data elements like dates and zip codes in the information that can't be retained under the safe harbor method. So this can allow for some more flexibility here. And so that's important to keep in mind. If
David,
we,
there's a question here, and I think it's
course.
a good one because it's relative to the mighty 18 list. Does the name of a community, is that considered as one of the identifiers? So I'm assuming the question is really about like a town name or a
yeah,
village or
so yeah,
something.
no, that's very on point for what we were just talking about. And so the name of any geographic subdivision that's smaller than a state would have to be removed under the HIPAA safe harbor. So that would include, let's say, a town in which somebody lives, a city in which somebody lives. So that's a good question, but those would have to be removed. Now, they may be able to remain in something called the limited data set that we'll talk about in a moment, or under the expert determination method. It's possible the expert could determine that the name of somebody's town in which they reside could actually remain in that data set, which is another reason people may want to use expert determination as opposed to using the safe harbor method. One other thing that expert determination can allow, depending on how it's done, is it sometimes allows the creation of linking codes that could be used to link different data sets to privacy protected methods of linking different data sets and matching like patients amongst those data sets. But again, it's very fact specific, and you should explore that with your counsel and your statistical expert who helps with expert determination.
So David, another good question here on the expert determination thing. It says, does the expert also have to justify why such method is used over the safe harbor method, not just the justification for the determination itself?
Yeah, so the privacy rule doesn't require that you justify why you're using expert determination as opposed to safe harbor, but they do have to document how they've come to the conclusion that the risk is very small that the information could be used to re-identify an individual. And one thing to watch out for with expert determination is that the expert will put limitations on how the data are used sometimes. So they'll say, like, if you're going to be sharing these data, this is the type of provisions you need in a data use agreement in order to ensure the data remain de-identified, or they may place limitations on the linking of data sets because they think if you're going to link two data sets, that may cause the data to be re-identified. So if you have plans to be doing any type of linking and you're going to be using expert determination, it's important to take that into account early on so that the expert can be aware of it and take it into account in his or her opinion.
Get a lot of good questions coming in here on this, so we'll try and get them while we're here.
Yeah,
it's a really good one. It's kind of like, how do you find these folks? So how does one find the experts to do the expert determination?
Yeah.
That's an interesting question.
I would say it's a cottage industry. It's a fairly small industry in the United States of individuals who do this work. And so usually people find somebody by word of mouth through universities that they work with. I suspect Nick has people that his department has worked with before. And then there's also some companies that do it as well. But a lot of the people are individuals who often are associated with an academic institution. So.
Now, one more thing, because I've got two questions that kind of overlap. It's, is genomic or other omics data and sequencing and proteomics, how does that relate relative to the 18 identifiers, since you could use it in combination to identify an individual? And are there any special considerations about that?
So from a HIPAA standpoint, the Department of Health and Human Services has not said under HIPAA that genomic information is inherently identifiable or that the genomic information is the 18th identifier. So HHS has not said that. That being said, I'm going to talk in a little bit about how there's state laws that govern genetic information in particular. So it is important to keep in mind, if you're dealing with genomic information, how it's regulated from a state law perspective. I'm thinking, and I see in the chat here, somebody was asking about GDPR compliance, which we're not going to get into a ton of detail today. That could be a whole hour in and of itself. But under other laws like GDPR, it's also important to consider whether genomic information would be considered personal data under those laws to the extent they're relevant for the transaction you're considering. So I think with that, we'll move to our next slide. These are all great questions, and you're all anticipating exactly where we're going. So an alternative to using a de-identified data set, and remember, de-identified data is no longer PHI subject to HIPAA, is to use what's called a limited data set. And this is a construct within the privacy rule that permits a covered entity to remove most of the identifiers, most of those 18 identifiers from a data set, but to retain dates. So you could retain treatment date, date of birth, and state, city, and zip codes. So geographic subdivisions that are less specific than a street address can remain in a limited data set. And a limited data set is still PHI, which is going to be relevant in a moment when I talk about sales of PHI, but you're able to use or disclose a limited data set without patient authorization, without patient permission, for research, public health, or healthcare operations pursuant to a data use agreement. And HIPAA prescribes the conditions of that data use agreement, the terms of the data use agreement. So let's say you're an academic medical center and you want to share a limited data set with an external researcher, you would enter a data use agreement with that researcher that meets the requirements of HIPAA. So this can be useful because it allows dates to remain in many cases. If we go to our next slide, there's restrictions, of course, on the sale of PHI in HIPAA. And this is important to think about if you're receiving any type of remuneration in exchange for providing. If you're a covered entity, let's say an academic medical center, you're receiving payment in exchange for licensing a data set or selling a data set. And so the general rule under HIPAA is that the sale of PHI is prohibited unless the subject of the PHI, the patient, is informed in a HIPAA authorization that they sign. So they have to sign the authorization and they have to be informed that the covered entity is actually going to receive remuneration in exchange for PHI. I will say this rarely used to occur because people had an aversion for having patients sign authorizations for sale of data. I will say in the last 5 years, I've increasingly seen this when we're thinking about a scenario in which there's a prospective consent from the patient, actually getting an authorization upfront for the sale to permit sale of PHI. A sale, as I mentioned earlier, takes place if the covered entity or its business associates receive remuneration directly or indirectly from or on behalf of the recipient of the PHI in exchange for providing the PHI. And there's an exception in HIPAA, though, that's important to know about, which is that a covered entity can receive remuneration if it's limited to a reasonable cost-based fee to cover the cost of preparing and transmitting the PHI, and that can include things like overhead costs, labor, time, materials. So you can obtain a reasonable cost-based fee to cover your cost if you're providing data for research or another permitted purpose under HIPAA. And it's important to remember, like I said a moment ago, that if you're dealing with a limited data sets are still PHI, and so they're subject to these rules on sale. If you're dealing with a de-identified data set that's fully de-identified under safe harbor or expert determination, that is no longer PHI. It's no longer subject to the limitations on sale of PHI. And so that might be one reason why you would prefer to have an expert determination that data are fully de-identified rather than relying on a limited data set, let's say, even if the two data sets might have similar identifiers in them. If we go to our next slide, the common rule is the set of regulations in the United States that governs research involving human subjects that's conducted or supported by federal agencies or departments. And so technically, if there's no federal funds or federal government involvement in a research, if it's fully industry funded or by the departmental funds of an institution, it may not technically be subject to the common rule. However, many academic medical centers, as a matter of policy, will apply these rules to research activities regardless of whether there's federal funding involved, okay? And some states apply the common rule more broadly to all research in their state, regardless of whether there's federal dollars at issue. So research is a systematic investigation designed to develop or contribute to generalizable knowledge. And someone who's a human subject for purposes of the common rule is a living individual, so decedents are not covered by the rule, about whom the investigator either obtains information or specimens through intervening or interacting with that individual, or obtains and uses their identifiable private information or identifiable biospecimens for research purposes. And so even when we're talking about data licensing transactions, you may have no intervention for research purposes with the individual. You're using residual data from patient care, as Nick talked about earlier. But it's possible if those data are identifiable, then this could be research involving a human subject because you're using their identifiable private information for the research. If we go to our next slide.
So David, a couple of
go ahead,
questions
please.
Here that are coming in. They're kind of
That's great.
relevant. So one question is kind of what is the definition of remuneration in a sales, cash, equity, royalties, anything you receive?
Could be any of those things, like anything of value that's received.
Okay.
could fall within the definition of remuneration.
Then a couple that are specific to kind of the context here. If data is shared as age and dates, is it still considered a limited data set?
So,
It was that
yeah,
nuance you were trying to make.
yeah. So if there's dates, then that could be limited data set, and age also could be included in a limited data set.
And then a really good question, I think is relevant to a lot of the academic folks, how do the restrictions play into uses such as publishing data connected with
Yeah.
research findings? And there's obviously a pretty significant change with NIH's open data policy coming up here this month that I think may be affecting this answer.
Yeah, so you have to be very careful if you're publishing the results of a study. You cannot publish the PHI unless you have the HIPAA authorization of the individual, or if you've de-identified the information. So it is important to make sure that there's appropriate permission in place for publications. And there have been even some litigated cases involving publications where people had said something was de-identified, but then there were dates included, let's say, and so there was a challenge as to whether the information had been appropriately de-identified. And so that is something to watch out for carefully, and I think there's attention to those issues by the plaintiff's bar. So I think sticking with the common rule for a moment, there is, of course, exceptions that might be relevant for data licensing transactions. If the information are not collected specifically for the research, so let's say it's leftover data from patient care from the medical record, and it's coded, let's say provided to the researcher in a form where they can't readily ascertain the identity of the subject, that may not be human subjects research subject to the common rule. And this is a little bit more flexible standard than in HIPAA. There's not 18 identifiers that have to be removed under the common rule, but rather the test is whether the researcher who's doing the research can readily ascertain the identity of the subject. And so if you put in place, let's say, a coding system, and there's safeguards to prevent that researcher from ever obtaining the link between the code and the individual's identity, that may take you outside the scope of the common rule for an activity. And if an institution is merely providing data and specimens to others for their use, that institution, if they're not involved in the research, they're generally not considered engaged in the research for purposes of the common rule, meaning that technically they don't need IRB oversight of the activity of the disclosure of the data. Now, I say that as a regulatory matter. Many of my clients that are academic medical centers want some role for the IRB to play, even if data are being just provided to another institution and there's no involvement of the institution providing the data and the research. They may still require IRB oversight. So you have to check your own institution's policies on that point. If we go to our next slide, the other thing, of course, is if you are subject to the common rule, then there'll be requirements for IRB oversight of the research, informed consent, which, as I mentioned earlier, is a different concept from HIPAA authorization, or an IRB can waive informed consent in certain instances. And then you also, under the revised common rule, have to make certain statements about, for example, biospecimens being used for commercial profit and data being shed of identifiers being used for future research. It's important to pay attention to those, as some of them will affect future transactions. If we go to our next slide, one thing I mentioned earlier, we had that great question about genetic information under HIPAA. You do have to think about state law in many cases. So for genetic testing, a lot of genetic testing of specimens taking place, genomic sequencing, and many state laws may require specific or explicit consent for the performance of a genetic test, but also in some cases the release of the results of genetic tests. And those state laws do not always match up with HIPAA with respect to what's considered de-identified or whether genetic information can be de-identified. So when you're entering in one of these data licensing transactions, it's important to take into account whether there's laws, relevant state laws that may impose heightened requirements or different requirements than HIPAA or the common rule on the sharing of genetic information. If we go to our next slide, we'll see that there's other sensitive categories of information that might be covered by state and federal laws. And so this includes mental health information, HIV/AIDS, information on sexually transmitted infections and diseases. alcohol, drugs, substance abuse treatment records, which are subject to a whole different body of regulation at the federal level, the 42 CFR Part 2 regulations on substance use disorder confidentiality records. So if you're dealing with any of these types of records, you should definitely check with your counsel to see if Part 2 applies. And there have been many changes to those regulations. As recently as a month ago, there was a major revision proposed that will have effect on research activities. So it's important to check that. And then biometric information, which is another category of information that's subject to heightened protection under certain state laws, like a law in Illinois that's often invoked in this area. If we go to our next slide, in international issues, somebody asked about GDPR in the chat. I do a lot of advising on GDPR and other international privacy laws. We don't really have time to get into those data restrictions in detail today, but it's important to think that if there's going to be any type of cross-border transfer of data in your transaction, so from Europe to the US or the US to Europe and back, it's important to think about whether GDPR may apply and what restrictions may be placed on the data due to that international transfer of data. And also, it's not just Europe anymore. There's other countries that have similar laws, like the China Personal Information Protection Law and Brazil's General Data Protection Law. All of these can become relevant in transactions involving those geographies. If we go to our next slide, ownership of data is a question, of course, that comes up, and this is a question that came up earlier in the Q&A. As a matter of law, it's always been a little unclear who owns the data, but increasingly we have state statutes that are governing certain types of data. And so genetic information, for example, there's a law in Florida that took effect last year, the Protecting DNA Privacy Act, that states explicitly that people have a property right, a property interest in their genetic information. And so that's something else to watch out for when you are dealing with data. As a contractual matter, and this gets back to the question posed earlier about who owns the data from a clinical trial, you also have to review the contracts that you have with the sponsor of the trial or the funder of any trial. Typically, it will say that the institution owns the underlying medical records, so any information put into your Epic system or whatever medical record system you use, but the sponsor will own the information that's collected on case report forms that are provided to the sponsor. The sponsor also often owns all the biospecimens that are collected for the trial, and that's sometimes a negotiated issue in clinical trial agreements.
So David, there's relative to the specimen comment, there's a good question that I've heard several times. It's, can you speak a bit more on the transfer of specimens, even if de-identified, given current ability to analyze and potentially identify or re-identify specimen data?
So it's a good question. From a HIPAA standpoint, HIPAA doesn't regulate the biospecimen. It regulates the information that might be attached to that biospecimen. And so if you were to shed all labels from a biospecimen, so there's no PHI attached to it anymore, you'd be outside the scope of HIPAA. And from a common rules perspective, it's not yet the case that all specimens are treated as a human subject. That was a proposal, and back in 2015, when there was a big proposal to revise the common rule of rulemaking that went on many years, the initial proposal was that biospecimens would inherently be treated as a human subject and subject to consent requirements. That approach was abandoned in the final rule that came out in 2017. And it was abandoned in large part due to opposition from the regulated community, that was a sea change and people weren't willing to go that far because it was going to hamper or hinder research, really.
So it's kind of in the same vein of specificity type questions. If PHI, specifically facial images, are absolutely needed for a research study purpose, what is the best mechanism to transfer such data? If HIPAA authorization is available, can it be shared via a traditional data use agreement?
So a facial image is considered inherently an identifier under HIPAA. It's considered a biometric identifier. And so the facial image can't really be de-identified in many cases. However, you could obtain the patient's HIPAA authorization for the disclosure of that image. And technically, from a HIPAA standpoint, you wouldn't need a data use agreement if you have the authorization. But typically, as a matter of practice, you are going to want some type of agreement in place that governs the recipient's use of that information. If we go to our next slide, and we just are coming back a little bit to Nick's presentation. that you have to consider, what are the types of data at issue? Were they collected in treatment or research? Your use has to be consistent, of course, with any consent that was obtained for the patient, and the HIPAA and privacy requirements we just talked about. And so if we're talking about data collected in treatment, that might require looking back at what is the treatment consent that the patient signed. What is your notice of privacy practices say? If you're a covered entity, that's a document that has to go on your website and be provided to patients at the first time they receive care that talks about how the covered entity uses and discloses PHI. Does it talk about, for example, use and disclosure of limited data sets or use and disclosure of PHI pursuant to a waiver of authorization? And then you also have to look, if it's a research study, what were people told in any research consent that was being signed? And common issues that I see when looking at consent documents, even if there's some nod to future use, is that it'll limit that future use by saying, well, there will be future use, but it'll only be done by institution researchers, or it'll only be done by non-commercial researchers, or for non-commercial research, or for research on certain conditions, or there might not be appropriate consent if we're going to be doing genetic analysis, genetic testing going forward. And so that is one thing to keep in mind when you are analyzing these data. Another thing to keep in mind is just the contractual issues of like, was there a clinical trial agreement that governs this? So if we go to our next slide, the restrictions on the use of data also may come from other sources other than just the patient and subject consent and authorization. And this goes back to some of the questions in the chat. There might be a sponsor that is limiting how the data can be used, like you can't use it with any other commercial entities. And then the sponsor may have certain confidentiality or ownership restrictions of places in its agreements. And there's also a limited permission. Sometimes there's a license back of data that's collected in a study to the institution to use it for internal non-commercial research, educational activities, or patient care and publication. So that can be limiting. And there's also, of course, if the data is collected in treatment, what I see sometimes, like traditionally in the treatment context, the academic medical center has information in its medical record. It can use it as it wants when bound by HIPAA and other regulatory requirements. But what I sometimes see now is people are contracting with like clinical laboratories that are external to the entity to do certain testing. And sometimes the services agreements with those laboratories may limit how the data are used when they're sent back to the medical center. So it might only be able to use for treatment purposes, but not all research purposes. They're not out licensing to competitors of the laboratory that generated the data. So it's important to look at that. And I also wanted to correct one thing I said a moment ago, which is that full facial images are definitely identifiers under HIPAA, although they're technically not considered a biometric identifier. They're their own identifier. Just wanted to make that clear in case someone has questions on that later.
There's always some good questions related to that. It's like, how are voice recording?
How our voice print. Yes, I see that. Yeah, how our voice recording is considered. So a voice print is one of the biometric identifiers under HIPAA. And so a voice print would have to be removed in order for data to be considered de-identified. And I've been dealing with voice prints a lot in recent years because they're of great interest to the life sciences industry and certain devices, medical devices. And so it's important when dealing with a voice print to think about state laws on biometric identifiers, like Illinois, Washington, and Texas have laws in this area. Other states are considering them because those laws don't necessarily have the exceptions for research that exists in some other state privacy laws. So it's a good question. If we go to our next slide, and we're just wrapping things up here, the last thing, this is kind of going off in a different direction, but to have a little bit of more holistic presentation today, I did want to note that when you're talking about arrangements, if you're a tax-exempt entity, as many academic medical centers and universities are, you do want to analyze whether you're receiving fair market value in transactions with for-profit companies. And engaging in arm's length negotiations. And this has to do with the IRS's private benefit rules, that if a tax exempt entity is providing data, let's say, for less than fair market value, that could be seen as giving a private benefit to a for-profit company. And also, you'll want to think about if you're an academic medical center, you're furnishing goods or services that are billed to federal healthcare programs like Medicare or Medicaid, or even commercial health plans. I'm thinking about, is this a commercially reasonable transaction conducted at fair market value? Because if you're providing something of value to a third party that might be in the position to refer business to you, that is payable by Medicare or Medicaid, the fraud and abuse laws could become implicated. So that again could be another whole presentation in and of itself, but I note that just for issue spotting to be aware of in this area.
So David, there's a couple of questions related to valuation that maybe it's a good time to answer. A very good university question. Can the quote reasonable cost-based fee include university indirect costs?
Yeah, so the reasonable cost-based fee is a concept from HIPAA that's talking about sales of PHI. And it can include both the indirect and direct costs for preparing the PHI. There's actually very good guidance from the Office for Civil Rights that I would direct you to in the preamble to the final the Omnibus Privacy Rule in 2013 that gives a list of the types of costs that they think could be included in that fee. And so I would direct you to that or your counsel for more specifics.
Great. And is the covered entity required to share any part of a sale or a revenue transaction with the subject?
No, that is not required. The covered entity is not required to share any revenue. As a matter of HIPAA, they're not required to share that with the subject. I think, are there any last questions you wanted to go through?
Yeah, there's a couple of ones that are kind of hanging out there still, but maybe we can kind of take these at once. It's, do patients have to sign a consent for physicians and hospitals to use their scans as data? I think it's very specific to the notion of a scan.
Yeah, I think the question would be, are the scans, what type of scan is it de-identified? How does it fall within HIPAA? Were there any was it collected in a research study in which there might have been a consent sign that placed limitations on how it could be used? Nick, I don't know if you have any other thoughts from their practical experience working at the medical center.
Yeah, no, exactly what you just said. If it was a scan, if there's scans that are collected as part of routine clinical care, then it would follow all of the same rules as anything else that we've been talking about with regard to, do you need them de-identified completely according to Safe Harbor? Is limited data set acceptable, and then you need your data use agreement, that type of thing. So the fact that they're scans per se doesn't necessarily change that. I would only comment that as we covered a little bit here with sort of how some of the fun ways that technology is changing, if you were to want to obtain for example CT scans of a patient's head or MRI scans of a patient's brain, those are likely to include their face. And technology being what it is, and the resolution of the scans now being what they are, it is becoming conceivably possible that you could take those scans and reconstruct the patient's face. And at that point, you then have to deal with the same rules we've talked about with regard to, potentially facial photography, because the concept is, could I then use those reconstructed scans to do facial recognition, and therefore it's not necessarily de-identified. But apart from that, it's a data unlike any other, like any other, I would say.
Good question here about, are there any resources that you could recommend regarding biometric identifiers at the state level?
So the International Association of Privacy Professionals, IAPP, I think may have some articles on their website that discuss them. So that would be one source to look at.
And I think this is a good question. It's if the healthcare entity owns the EMI record and the sponsor owns the CRFs and the data in them, are we in a position where some of the data that are in both records is owned by the sponsor and the healthcare center? So it's kind of this notion of it being a bit of a divided interest, I guess, on a few of these pieces.
Yes, I think that's right. Because if the information is in the medical record and that medical center owns the medical record, they'd be the owner of those data. And there might be another copy of those data that's owned by the sponsor that was in the case report form. I think where you may run into challenges is there's information collected in the case report form that's not in the medical record or collected in the study. I see Nick nodding. It seems like you might have similar thoughts on that one.
Yeah, I think if you wanted to try to collect data that is unique to the case report form, then that's subject to whatever agreement was signed with the clinical trial sponsor. And that's not something that would also be, frankly, difficult for us to mine out of our system anyways, because that data is likely stored in the sponsor system, not in our system.
And I think the last couple here are really just kind of this notion of fair market value and kind of what can you really charge. It's, who determines fair market value, and then is really the licensing cost limited to or the licensing opportunity limited to revenue associated with recovering what it was needed to collect the data. So it's that notion of kind of the tension between cost recovery and then really what the market would bear.
Yes, I think the first question is about the licensing data. If there's no licensing fee or if revenue is limited to costs. So that limitation to recovering costs is specific to HIPAA and sales of PHI. So if information is not been de-identified, or it's still in the form of a limited data set, then you have to consider the rules on sale of PHI under HIPAA, and whether you can limit what's being collected to a limited cost-based fee, or reasonable cost-based fee, I should say. If you have fully de-identified data, then those limitations aren't relevant, but you still want to have like an arm's length negotiation and fair market value of the data from a tax perspective. Oftentimes, if you're dealing with a tax exempt entity, or from a fraud and abuse perspective, if it's an entity that is in the billing Medicare and Medicaid or other payers for services.
I would also comment too, because I know we're talking about value, and I hate to do this at the end because we're over time and this is worthy of its own discussion again. But coming at it purely from like my academic perspective, because I would often, be asked to review some types of data requests and stuff. If we were to get a request from a third party saying we would like the following types of data, we will pay you X amount per patient, or we would like to negotiate, X amount per patient, and that's the extent of the request, we will almost certainly reject it. The concept from an ethical perspective of simply having it appears that we are selling patient data, particularly to a large academic medical center, is usually not terribly tenable. And you almost always, there's going to be a few people like me on the committees that review these saying like, no, we need more justification than just it's legal. Can we buy data from you?
Right.
And so that's where these discussions often start. There continues to be literature on, the ethical frameworks surrounding how these types of data can be licensed and sold. And so I know it's totally separate from here because you're looking at, well, what's the practical way that I can just get this data? And at least part of that practical way is there's going to be some people that are going to be reviewing these requests that are going to be thinking about it from like my perspective of, well, what's the appropriate ethical way to do this? And so what other types of rules need to be put in place, even if HIPAA doesn't require it, even if it's not, under the common rule, because we want to make sure that if the agreement that we had signed became public, what would our patient population think about this? If the data was delivered without explicit authorization, because legally we were able to do it, with a waiver or something like that. So these are all things worthy of discussion, but I know we're out of time now.
Yeah, I think part of an interesting discussion that the committee that was helping to develop the program is about this exactly, and there's not the same long laundry list of benchmarks and things like that, but you raise a very good point, Nick, in the sense that just because you can, should you, and is that the charter of your institution versus this is part of a bigger sponsored research.
Different institutions almost certainly have their own perspective as to what they're willing to do, regardless of whether or not it's legal for them to do it, and so there's continues to be discussions about that.
Great. There's a couple here real quick. We'll try and answer them if people can hang on. It's our data use agreements required for de-identified data. I think I might have missed that one in there at some point. Sorry.
As a matter of HIPAA, they are not. If data are fully de-identified, you don't need a data use agreement. However, many institutions would choose as a matter of practice to have a data use agreement, even if the data are de-identified, to control the uses and make sure they're consistent with the institution's mission.
And I do think that will be explored more extensively in the what can you do with the data type of in the future webinars. So certainly come back, you'll hear more about that. For an entity with a hybrid covered entity, does one need a DUA to transfer limited data set from covered component to non-covered component? So it's almost like, it sounds like an inter-institutional transfer.
So this is a really technical question. So many people may not know what a hybrid entity is on this call today, but a hybrid entity, often universities may be hybrid entities, for example, is where you have one legal entity and a portion of the entity is, let's say, a healthcare provider that provides billable services and submits claims that's subject to HIPAA. A separate portion of the entity does not do those activities, let's say like the psychology department or biology department at the university. And so often those entities set themselves up so that there's firewalls between them so that part of the entity is covered by HIPAA, follows the HIPAA privacy, security, breach notification rules, and the other part of the entity doesn't. What this means, though, is the disclosures of PHI from the covered component, the healthcare component of the entity, to the non-covered component have to be generally treated as disclosures from a covered entity to a third party, some external third party. So if you're disclosing a limited data set, then you would need a data use agreement between those two, the covered component and the non-covered component. And the HIPAA privacy rule, even if you're disclosing a limited data set within a covered entity itself, technically the privacy rule does require a data use agreement. It's quite explicit on the recipient of the data signing a data use agreement. Nick, you may have practical thoughts there because you may be working in a covered or a hybrid entity.
Yeah. So we, I believe we were considered a covered or a hybrid covered entity for sure, because I know that we would need these types of agreements if there were folks within our biological sciences division who were considered part of the covered entity wanting to do, for example, a research project with folks from our business school who were not. And so you would have to have an agreement within, I mean, it would seem like from the outside, it's an agreement between two different departments within the institution, which it technically kind of is. So yeah, I can definitely speak to, I know that that is a practical reality for some places, depending on, you know, again, if you are a hybrid entity.
Great. Then one last note here. This is kind of from the questions I received earlier. I think it's a good one, as always, about clinical notes and just basically free-form text. And are there any special considerations or things people should think about relative to that? Because it's generally significantly less structured than obviously a test result or something like that.
Yeah, I mean, from my vantage point, from a practical standpoint, you know, de-identification of even structured data is not trivial, and de-identification of something like narrative, you know, physician notes and stuff like that is absolutely not something that can be done simply. There's research, wide swaths of research being done on machine learning specifically for the purposes of de-identifying data by a natural language processing. It's almost its own field in and of itself. So from a practical standpoint, I think a lot of thought and care needs to be put into what you're collecting, how de-identification is being handled, you know, and then who's responsible for doing it, and how the data, once it's been delivered, is being handled and reviewed, right? You know, it would be a mistake to consider any de-identification process to be 100% perfect, because almost assuredly it is not. And if you're just assuming that it is, or someone's trying to tell you that it is, they're wrong. So you need to have methods and procedures in place for, you know, reviewing the data, handling it appropriately. If you do come across PHI in the data that you're handling, you know, what is the appropriate method to deal with it within your data set? You should have, you know, rules in place for dealing with that. So certainly from a de-identification perspective, it's not trivial. You need to think about it. And like, we always look at sort of a minimum necessary rule too. Like, do you need this data to do the project that you want to do? Which also inherently means you need to tell us what project you're trying to do. Like, what is it that you need to do? I saw a question go by about copyright of that type of data. I will defer to David if that is at all relevant when it comes to physician narratives or physician notes. I have no idea.
Yeah, and that's something I'm not an IP attorney, so I don't advise on copyright generally, but that's not a question that I've ever gotten before or seen come up in this area, but that might be something addressed in one of the future webinars.
Yep. And I would point people to the third webinar, Nick, relative to the free form text thing, and really process around that, what you want to be mindful of with respect to, you know, how you're licensing that, and specifically when that happens, because I think you're right that if you think the process is foolproof, that's probably not a good assumption to make. But with that, Kirsten, we'll turn it back to you. I appreciate David and Nick, just outstanding presentation and really, really fantastic fielding of a lot of great questions. So thank you.
Right. Terrific content today. It was a lot of information. We are definitely over time. Thanks for so many of you actually sticking with us. We still have over 200 people sticking around with us. But thank you everyone for sticking with us. We do have a survey. If you can fill that out, it's 5 questions, super short. It's in the chat, but it'll also be when you quit out of the webinar, there'll be a short survey there. So please do answer that. We really appreciate the responses. They help inform us about the future webinars, and also for this webinar series will help us what else we're to address under that. So thank you, Nick and David and Drew for kind of laying the foundation for the rest of this webinar series. Really appreciate your expertise, was just phenomenal today. Thank you for bringing it. Thanks to Ropes&Gray for helping set up the CLE credits. We're going to be sending out the information about the CLE afterwards as well, just in case you didn't get it before. So thanks to them for that. Thanks to our audience members for joining us. We've already gotten a lot of thank yous in actually through my email. People thanking us for this particular webinar series. It's really a lot of information that people are grappling with, trying to figure out how to work with appropriately. So thanks for attending today. Thanks for being here as our panelists. We are going to have the next series for this webinar on March 21st. So keep an eye out for that registration. It should be coming out in a couple of weeks. In the meantime, we wish everyone a healthy as winter as possible. Enjoy the rest of your day. Thanks everyone for joining.